that buzzer like the mayor has. I don't know, or gavel or something. We'll probably have some folks filtering in as we get started here, but we'll go ahead and get started. It is 1:30. Good afternoon, welcome, and thank you for coming. My name is Jason Woodbury. I'm Carson City's District Attorney. With me here today is the Chief Civil Deputy District Attorney, Adriana Freilich, and Joe Ward, who works in the Civil Division in our office. This afternoon, we'll be offering to you the first in what we hope will be a recurring series of presentations designed to help you better fulfill your role as a Carson City employee, appointee, or elected official. Today you will be hearing from three experts in the field of public integrity laws. But before we get to them, I wanted to take just a couple minutes for myself and talk to you a little bit about what we're trying to accomplish here today. Sometimes these presentations can come off in the wrong way. These experts that you're going to hear from today are going to be up here talking to you about the law in their particular field and the rules and the exceptions to the rules and where there might be some gray area in the rules. And that's all very important. It's important to know those things and important to remember those things. But I don't want you to feel like you need to walk out of this room today feeling like a legal expert. The taxpayers of Carson City pay me and Adriana and Joe and our team an awful lot of money to help guide you in these areas. So let us help you when you need it. Our policy presently is to have a deputy district attorney attend every meeting of every board, every commission, every committee of Carson City. So you should have a live body at all of your meetings. If you're not sure of who your assigned attorney is, we brought along a sheet that's on the table at the back of the room that shows all the assignments in our office, and I encourage you to grab one of those so you know who your assigned attorney is. Certainly between those meetings, I want you to feel free to contact our office at any time. My folks are well aware of their obligation to be as responsive as they can possibly be to phone calls, emails, and any other requests that you might make of our office. And you need to feel free to contact us with any questions that you have rather than trying to take these issues on yourself. Some of these issues can become very complex, and there are areas of the law that are somewhat unclear, and you need to use us because that's what we're there for. Now, we will respond to you as quickly as we can. If there ever is a circumstance where you have an issue and for one reason or another you haven't gotten a response as quickly as you need it, I'd like you to write this number down. That's my cell phone number, and you can call me. You should never need to, but in the event that you are in a situation where you need a direct answer, I want you to call me. Now, we're going to spend today talking about the laws. And compliance with these laws is an important element of good government. But compliance with the law is the starting point for good government, not the ending point. And I suppose that it probably sounds a little corny, but in words that are woven within the fabric of this nation, so much that they are really a part of who we are supposed to be a government of, by, and for the people. And for a century and a half, we've taken President Lincoln's words and we've lawyered them up. So now we talk about open and transparent and ethical government, but we're really talking about the same thing as what he said. And we're really talking about some very basic concepts, when we talk about open and transparent government, we're really saying that we want people to be notified of what government is doing and what government is thinking of doing. We want people to have access to the same information that our leaders and public employees and public officers are using to make their decisions. We want people to have an opportunity to provide input to those decision makers. And we want those decisions debated in public so we can understand, we the people can understand, not just what the decision is, but the reasons that the decision was made. And we may agree and we may disagree with that, and based upon whether we agree with a decision or not, we may take certain action when election time comes, but it's vital, it's essential that we understand and hear and have an opportunity to understand what the reasons are for the decision that was made. When we talk about a government that is for the people, and today we talk about an ethical government, all we're really saying is that we want some assurance, some legal assurance, that that decisions are made based on an honest assessment of what is in the public's interest, as opposed to being a product of an elected official or decision makers or employees' personal self-interest. And that's where these laws fit in. They fit in, they provide a basic structure and a roadmap for how we accomplish the objective of being a government of, by, and for the people. So as you listen today, please take these presentations in the spirit they are intended. We didn't invite George Taylor here to talk to you about the open meeting law so we can all figure out a way to get around the open meeting law. We didn't invite Ms. Navarez-Goodson here to talk to us so we can find some loopholes in the ethics in government law. We have asked them here today so that they can help us, all of us, deliver a better government to the people of Carson City. That's the spirit that these presentations are offered in. So, with that, I'd like to introduce Yvonne Navarez-Goodson. She is the Executive Director of the Nevada Commission on Ethics. She's been the Executive Director, I believe, since 2014. And prior to that time, she did serve as the Commission Counsel, the legal counsel for the Nevada Commission on Ethics. She's brought with her today, I'm grateful to you for bringing her, Tracy Chase, who has been appointed the Commission Counsel and is now serving in that position. And we need to listen very closely to Ms. Navarez-Goodson, because if you try to get around the ethics laws, she will take you to the United States Supreme Court. She has done that before with somebody. So, Ms. Navarez-Goodson, I'll defer to you. Thank you.
Are we set up on the same one? Are we set up on the same one if I just keep going, or do we need to? Okay. Well, I'll just jump in while Adriana is helping me with the PowerPoint. Thank you for having me here today. As Jason mentioned, I'm Yvonne Navarez-Goodson, and I am the Executive Director of the Nevada Commission on Ethics. Lucky for you folks, however, of course, is that you do have Adriana backing your every move. And those of you who don't know, Adriana started her career, or maybe not started it, but certainly early on in her career, she was also the Ethics Commission legal counsel for many years. And so she, of course, created the great foundation that I got to work with and that Tracy now gets to work with. And so if you do have questions about ethics and government law, she's certainly a great resource. But of course, my door is always open. My phone is always open to you, as well as that of Ms. Chase. If you do have specific questions about specific conflicts of interest that you might encounter in the course of your duties as public officials or public employees. I do usually have a 2-hour presentation, so I'm going to truncate that quite a bit and try to get through this in about 30 minutes or so, and then open the door to any questions you guys might have about specific issues I've discussed. I would probably suggest that if you have a more specific question to a particular conflict of interest you might be facing, that maybe you would call me after and we could talk about that, or certainly you want to talk to to Adriana or Jason about those issues first. And the reason that I'm going to have you do that is because if you do rely on their very accomplished and significant legal counsel, you could get a safe harbor. We'll talk about that a little bit later on as well. But generally, the Ethics Commission is an 8-member commission. It's a state-appointed public body. We're half appointed by the legislature and half appointed by the governor. Each of these members is statutorily appointed in a way to make us as neutral as possible. So we can be no more than 4 of any major political party. We can be no more than 4 from any particular county within the state. And the goal for that, of course, is that whoever appears before us, we do have political beings that appear before us. The goal is that it's neutral. It's never going to be swayed by one political affiliation or another, by one geography or another. And that's the goal of ethics and government law, to make us as fair and as reasonable and as diverse as possible. This commission, you guys probably hopefully have the handout to this. We are staffed, this commission is staffed by only 6 people. We are a statewide commission, as I mentioned, but we're primarily located up here in the north, but we do, of course, appear down in the south and handle cases all the way and all throughout the entire state of Nevada. The staff includes myself and our commission counsel. Both of those positions are appointed directly by the commission. And then as the rest of the staff's appointed generally by the executive director, some in consultation with our commission counsel, but they include an associate counsel position, our senior investigator position, and then our more support level staff of our paralegal and our executive assistant who helps with the budget and more of the administrative elements of our work. Jurisdiction of the commission. We do have very limited jurisdiction. It's limited to public officers and public employees, and it's limited to 2 years of their conduct. Public officers and public employees are also specifically defined in the ethics and government law. So a lot of us might think that we're public officers, but we may really only be public employees. And if we serve on bodies that are advisory in nature only, then those individuals are not going to be deemed public officers under the jurisdiction of the Ethics Commission in the ethics and government law. The prime example I have of something like that might be members of a planning commission. Planning commission members are generally thought of as advisory bodies to the county commission. However, the ethics commissions looked at that issue and said, wait a second, the planning commission itself has final decision-making authority over various issues, for example, special use permits and variances. And so the commission has said that in those capacities, they're not advisory in nature, and therefore planning commission members are public officers under the scope and jurisdiction of the ethics and government law. However, there might be other boards and committees that are affiliated with the Carson City Council or Commission here. And it might be that you're solely in an advisory capacity and you may not be deemed to be a public officer under the specific scope of the jurisdiction of the Ethics Commission. Now, that doesn't mean that our principles should be ignored by you. It might mean that we technically won't be able to come and get you if you get something wrong, but the concepts of ethics and government law are nevertheless probably something you should carry forward in your duties, because you're probably serving in that capacity as a benefit to the people of your jurisdiction. Oops. That's okay. It's not working. I have my flash drive. Okay. Time out. Sorry about that. Can you guys hear me on this microphone well enough? Is that better? Okay, great. I'm going to skip through a couple of these just because we've already gone through some of that, and I'm going to speed things up because I know I'm taking a little bit too long. This slide, actually, I will comment on it. It makes me laugh a little bit. For those of you who are public employees and not public officers who might serve on committees, you still are subject to the ethics and government law. And one of the things that we see most regularly with our public employees as opposed to our public officers is that they often think that their government equipment and their government time belongs to them when they're at work, and it really does belong to the public. So the advent of the internet and YouTube and all of these things was heartburn for the Ethics Commission, because we were getting a lot of calls for a long time from various public employers saying, how do I control my employees from spending 5 hours a day shopping on the internet? And our response was to say, file a complaint against them. Tell them the Ethics Commission will come and talk to them about it. But in all seriousness, our efforts are certainly not to prosecute and go after public employees and public officers. Our goals are really to provide outreach and education and show you what the boundaries and the limits are to prevent that type of conduct and to make sure that we're preserving the public trust and that our public resources are used for the right reasons. I think where I left off before my quick break was talking about the jurisdiction of the Ethics Commission, which, as I mentioned, is public officers and public employees. But we do conduct primarily two major functions. The first is that we do provide advisory opinions to our public employees and public officers, which means that if you have a specific question about a potential conflict of interest and you're not sure how to conduct yourself within that conflict of interest, you can come to the Commission and request what's known as a first-party request for advisory opinion. Now, that's a lot of words to mean that you can come and ask for a formal opinion from the Ethics Commission about how you might navigate the waters of NRS 281A with regard to your particular conflict. That process is a confidential closed hearing process. The Commission will ask you to come before it, provide testimony under oath about the nature of your circumstances, and then it will interpret the provisions of NRS 281A in light of the facts that you've presented to it. Typically, you'll get advice at that same hearing. The Commission will deliberate in your presence and let you know kind of what they're thinking and their approach to your problem, and then they'll give you an oral decision. That oral decision is then reduced to a written opinion, which becomes precedent, if you will, for the Commission. It's how we will interpret future circumstances that might involve the same set of facts and circumstances in the future. I did, of course, mention that that process is entirely confidential. It's within your rights to waive that confidentiality or to retain that confidentiality. If you choose to retain that confidentiality, that opinion that is directed specifically to you will remain confidential, but the Commission will prepare what's known as an abstract of that opinion, where it will sanitize your name, your position, anything that might identify you as the requester, in the hope that that abstracted opinion will provide advice to your colleagues and your other public officers and employees throughout the state who might be faced with a similar conflict. The second major function that the Commission engages in is, of course, our complaint process. These are known as our third-party requests for opinion, wherein the Commission receives complaints from members of the public alleging that its public employees and public officers have violated a provision of NRS 281A. In that context, the Commission will engage in a series of activities designed, hopefully, to protect your due process rights, wherein you'll be notified of the fact that a complaint's been filed. You'll have an opportunity to respond to that complaint. And through various levels of review, the Commission will determine whether or not there has, in fact, been a violation of the ethics and government law. The first stage of that is going to be a panel decision. And so you might think of it, and we're certainly not a criminal agency, but you might think of it in the context of a preliminary hearing. So what'll happen is our investigator, through the executive director, myself, will evaluate all of the information that we've learned through the course of an investigation and through an evaluation of the response that the subject has provided to us. And we will present all of that information to an investigatory panel of our Commission, which is 2 members of the Commission who will look at that evidence and decide whether there is sufficient evidence available for the Commission as a whole to render an opinion in the matter. Sometimes that evidence won't be sufficient. We do have a different standard of proof that we have to reach when we get to a hearing, which is a preponderance of evidence. And if we think we're not going to be able to ever make that standard, or if the evidence isn't going to be sufficient to go there, then the panel might dismiss the case at that point. The protection that's in place for individuals who are the subjects of these complaints at this point in the game is going to be that the entire investigatory process up and through that panel hearing is going to be confidential. So the commission will never confirm or deny to the public that we've received the complaint, that we're investigating it, that you're the subject of it. Any of those things would remain confidential unless, of course, you waived that. Now, what happens as a practical matter, the requesters of these complaints do get wind that they've, of course, been the one to file them, and they get notified that we've accepted them and will or will not investigate them. And the requesters sometimes are the individuals that go to the media and go to the public and say, look at this form, the Ethics Commission's investigating you. And though sometimes disingenuous, we will respond with, we can't confirm or deny that, because we will do our best in every effort to protect the confidentiality of that process and the integrity, frankly, of the investigation. Now, we're trying to work on some of these issues in the legislature, so we'll see what happens. But we certainly aren't going to infringe upon someone's First Amendment right to speak to the press. So the only thing we can control is our own conduct, and that is, of course, neither confirming nor denying the existence of such a complaint. But the reason that I talk about these issues at the outset is to kind of give you an idea of what the commission is and what it does, and why it's so important for us to learn the principles of ethics and government law and what it is we're trying to prevent from happening so that everybody's happy. The public that you represent is being represented with impartiality in your representative capacity that Jason so articulately explained, is that, you know, in our capacity as public officers and even public employees, you're working on behalf of the public. Your time doesn't belong to you, it belongs to the public when you're employed through taxpayer dollars. And we need to kind of keep those principles and those concepts in mind, because your actions that you undertake as a public officer and public employee are presumably supposed to be made in the best interests of the public that you're representing. And so hopefully that's kind of a general overview. I'm going to skip through a lot of these slides. I know you guys have a handout regarding the same thing, but I wanted to jump into, in my remaining time, what some of these principles are, the ethics and government law standards of conduct, if you will. We've often referred to them as our 10 commandments, since they're 10 provisions. But the statutory provision that's going to be relevant is going to be NRS 281A.400. And I'm just going to skip through quite a few of these, if you'll just bear with me. These are a lot of slides to explain what I just told you in a nutshell. But if you want specifics, you can certainly refer to that. Okay, so our prohibited conduct, the things you guys are going to want to be careful of when you're engaging in your activities as public employees and public officers. The first provision is something that we see fairly often at the Commission, and it's about public officers accepting gifts, economic opportunities, services, favors, or anything untoward like that that would tend to improperly influence their duties as a public employee or a public officer. Now, the reason that that language exists in the law the way it does, and sometimes people say, well, that's broad, that could encompass anything. But the reality is there are different levels of public employees and public officers throughout the state, through local government, through state government, all the way through. And the triggering words in this particular statute involve that would tend to improperly influence a reasonable person in that situation. So a $5 gift to someone might be nothing, but a $5 gift to someone else could genuinely influence a decision that they might make. If someone's buying them a cup of coffee every Monday morning and it's $5 cup of coffee from Starbucks, they might say, hey, this person, I'm going to do my best to get them what they might need. But for another person, that could be completely unreasonable, and a $5 coffee is something they might buy themselves every day anyway. And so I like to draw attention to those words simply because it's what would improperly influence a reasonable person in their situation. And so if you think you're being offered some type of gift, or if you're being offered a job opportunity or a favor, if you do this for me, I'll do this for you, think about how that might interplay with someone who's in your position and whether or not you're really being able to be impartial in the decision you make on behalf of the public that you represent. And we have a lot of case law about this particular issue, whether it's a favor, whether it's a job opportunity, whether it's a gift as ununique maybe as a scarf. Those types of questions have come before the Ethics Commission, and they address those to individuals to kind of help them know the guidelines. One of the big questions we get about this particular section and what the legislature is always trying to do is define what a gift is. And the Ethics Commission and the Ethics in Government Law specifically does not define gift because of what I just mentioned before, which is that it could be different for everybody. A gift might not be a gift if it's not going to influence someone to change their behavior. But you will see probably some gift definitions trying to come through with regard to the Secretary of State's provisions and things like that. So be aware and conscious of those issues, but know that even if you have a definition for a gift somewhere else, for example, what you might be required to disclose on a financial disclosure statement, that might be a gift of $200. But if you receive a gift of $50 and it's intended as a bribe, the Secretary of State might not care, but the Ethics Commission will. Secondly, we have a standard of conduct which prohibits the use of your position to obtain or secure an unwarranted benefit, an unwarranted privilege, an unwarranted advantage, something like that, through the use of your position. Now, once again, we have some triggering words in this particular provision of statute, which is an unwarranted benefit. It very well could be that you're being offered something, or you're using your position to acquire something that's appropriate. That's done in your capacity as a public officer for the benefit of your constituents or for the benefit of your agency, and it wouldn't trigger this provision of ethics and government law. Except there could be situations where you might be using your position, your power, your influence, your relationships that you've acquired by virtue of your positions to acquire something in a personal capacity. In the more egregious, outrageous circumstance, it could be obviously a bribe, which might cross over into some criminal stuff that the Ethics Commission wouldn't be worried about. But in the more general provisions, things that we don't think of every day, it could be something along the lines of, I'm not coming up with an example that might be too relevant to your work. It could be, for example, I'm going to vote on something that might decrease the rates that might be required of some type of utility. I know that's a bad example, but if you're doing that, you might also have a problem with a disclosure and abstention provision, but you might also be voting on something that you live in that district and it's going to benefit you, and it's not fair because it might protect your house more than anybody else's house, and you have to think about those things when you're voting in that capacity. If it's going to benefit you in your private capacity, pecuniary or otherwise, differently than it might affect your constituents or the people that you represent, you might think that it would trigger this particular provision of NRS 281A. We have a few more. These are two provisions that the Commission doesn't see all that regularly. Of course, they exist in the law because you can imagine those circumstances where they do happen, and it's not unheard of that it's happened in the past. But we do not want our public officers and public employees participating as agents of government to secure contracts that might benefit them personally. We might see this more often in a context, probably in a rural community, but we might see this in the context where an individual public employee or public officer had a private business on the side, and that business was trying to conduct contracts with the government, something like that. That would also trigger other provisions of NRS 281A, but that's where this type of provision is intended to come into play, and hope that you won't do those things. Secondly, we also don't want our public employees and officers accepting salaries or economic benefits from a private source for something they're otherwise required to do in their public capacity anyway. For example, it might be that a private organization would hire me to come do an ethics and government law training, and they want to pay me for it. But really, it's part of my job to come out and provide ethics and government law training. So I shouldn't also get paid to do this from the government and then take a stipend on the side from a public source. Again, these are another two provisions that the Ethics Commission does not see all that frequently. But we don't want our public officers and public employees using information that they acquire through the course of their public position that might not otherwise be available to the public to benefit their pecuniary interests. Likewise, we don't want someone suppressing information that's only available to them by virtue of their public position. I like to think of these two provisions, if I can, in the government sector as akin to sort of insider trading in the private sector. So we don't want you acquiring information that you can somehow use to your benefit or suppressing that information to benefit you personally if that information is not otherwise available to the public, because it doesn't belong to you, it belongs to the public. Oh, and then this is something that the Commission sees quite frequently, most particularly with respect to our public employees, and this is the provision of NRS 281A.400, subsection 7. And this provision prohibits public officers and public employees from using government resources, facilities, equipment, anything of that nature that belongs to the government for your own private pecuniary gain. This could be the copy machine. That paper doesn't belong to you. If you're making copies of something for your child's fundraiser, that's a private interest. That's not money that should be spent towards that when it's the government that owns that money. And I make light of that situation not easily, because that is a circumstance that the Commission sees. A lot of public employees frankly don't know that the ethics in government law exists, first of all, and secondly, they don't have that conscious appreciation that using the copy machine, using their computer, using the time that they otherwise owe to the government is actually a violation of NRS 281A. Now, there are some exceptions to this, of course, because we want to be reasonable. For example, if you use your government telephone to make a personal call and it's local, it's not costing the government anything, it's not long distance, your supervisor has approved those types of phone calls if they're not 10-hour phone calls during your entire shift, then that might be an appropriate use of government resources. It might be that you have an internal policy about the use of the internet through your government computer. And the Commission will look at those types of policies and those types of issues and say, okay, if this government entity has a policy in place that says it's appropriate to have nominal limited use of the internet during break times or things of that, then the Commission's not going to find that to be a violation. But those specific exceptions are listed in statute, and that includes, of course, if you have an emergency and you have to use something for that purpose. If it wouldn't interfere with the performance of your duties, if it's of nominal value, and if it doesn't create an appearance of impropriety. And you'll probably note in this statute the use of the word "and," because to have the exception apply, you must achieve all of them. So it could be that the value is pretty nominal, but the appearance of you doing that would be extreme, and so the Commission might say, it might not actually cost the government that much money, but that is so egregious, that so belongs to the public that you shouldn't be doing that. And so I would just draw attention, if you do have those types of questions about a particular use, please bring those to our attention, because we can help guide you about how the Commission might have addressed former situations that could be applicable to your circumstance. And we have two more. I'm wrapping it up, hopefully. Two more. We don't want you using your positions in government to improperly influence your subordinates for private, personal reasons. This can run the gamut of all types of circumstances. It could be that you have a private business on the side and you're asking your administrative assistant to do all this work that actually benefits your business. And I like to ask public employees and public officers to think about this provision not from how you might view a request of a subordinate, but how your subordinate might receive that request from you. And it could be something that you think is so silly, so easy, they could accomplish it in 30 seconds, it would be of great help to you, even though it's for your personal interests. But the subordinate could be thinking, if I don't do this, they're going to discipline me, or they're going to fire me, or they're going to retaliate in some way. And so I always like to ask public employees and public officers to think about the requests that they make of their staff and their subordinates, if it has anything to do with their private interest, to probably, number one, stay away from it entirely, because what you think could be so nominal and so easy really could be received much differently from that subordinate, and they could really be thinking, oh, I can do that really quick, no problem, just to make them happy. But that's not what they're employed to do. And then finally, I alluded to this a little bit earlier, but we also don't want public officers and employees seeking other employment or contracts through the use of their position. So we don't want you to be in your position in government to be there solely to be looking for the next thing, the next employment, the next private contract that might benefit your agents or your private business, or perhaps the private business of your spouse or your child or your nephew or something like that. So we try to make sure that public employees and public officers are aware that the decisions that they make should not be made in any way to try to benefit or line their personal pockets or those of the persons to whom they have significant relationships. And I did want to draw on that issue about the types of relationships that create conflicts for us. This is a pretty significant area of the ethics in government law, and one that's confused pretty regularly. And this is this terminology that you'll see in our statutes called a commitment in a private capacity to the interests of another person. And I didn't create that language, so that's a mouthful. But what that essentially means is that the legislature has deemed certain relationships to be statutorily, let me rephrase that. The legislature has said that your relationships with certain individuals are so significant that their interests are statutorily attributed to you to become your own personal interest, to create a conflict of interest. So what that means, in more layman's terms, is that you might have a conflict of interest because it could be your business that might be affected by a decision that you're being asked to make in your public capacity. Now, if it's your son that appears before you and it's his business that might benefit from a decision you would be asked to make, that commitment to your son is so significant that his business interests become yours by statute. In practice, that may not be true. You may not stand to benefit in any way from your son's business financially, but the law has said you're going to probably reasonably, realistically vote on something that's going to favor your son because your interests of your son matter to you. And so we want to protect the public from decisions like that. That's not fair. That's not you in your capacity as a representative of government being able to be objective about the issue that might be before you. And I talk in the context of voting members of various public bodies and various even advisory bodies, but that principle also applies to public employees in decisions that they might be asked to make. One of the examples that we just had recently was a woman who had called, and she was a file clerk for a specific state agency, and she would stamp in the applications that would come into her agency, and she had no supervisory decision-making authority with respect to this particular application, but it was a very lucrative application. And she saw one that had come in, and it was her son's business that was applying for this particular license. And her only responsibility with regard to these applications was to say, received on this date stamp, and pass it along. But she was concerned that it was because it was her son's application that she might be making a decision in her capacity as an employee that could potentially affect her ethics and government law, but could also potentially affect her son's ability to acquire this license. And our decision at that point was to say, you're really not making a decision with respect to the application itself for the license. And so you can stamp it and move on, but you might have a duty or a responsibility to share with your supervisor. Hey, as part of my regular duties, I stamped in this application and it involved my son, but I had made zero decisions about it. It might involve a situation like that. But the point I'm trying to make is that these provisions apply equally in different contexts to public employees as they do to our public officers. And I think I'm going to skip this and go into disclosure and abstention because that's kind of a big issue, and then I'll step off. Do I have time for that? Yeah? Okay. So I wanted to touch briefly on our disclosure and abstention provisions. I'm not exactly sure. I might have already passed this. Here we go. The most questions that we get from our public officers who are members of various boards and commissions is their requirements and their obligations to disclose various conflicts of interest and whether or not those conflicts of interest rise to the level that would require them to abstain from voting on that matter. And I think I referred to earlier the idea of what is a conflict of interest, and the question sometimes is debatable. It could be that you might think you're privately interested in something, but under the ethics and government law, they've been very specific to define what is a conflict of interest that requires disclosure and abstention. The first, of course, is if the matter that you're considering involves a circumstance in which you've accepted a gift or a loan related to that issue. That's not all that common, but it could certainly happen. It could be a private loan from a person who's before you. It could be that that person has gifted things to you, and so the perception is that there's some type of bribe by them appearing before you in your capacity as a public officer. But more specifically and more realistically, we have any issue that might be before you that would involve a significant pecuniary interest, or what I referred to earlier as a commitment in a private capacity to the interests of others. That would probably, presumably, be the most identifiable for you because you would know if an issue that you're being asked to vote on or act on involves one of these specific relationships, which are also defined in statute. And pecuniary interests, if your pockets stand to benefit by virtue of a decision you might be asked to make, then you probably have a pecuniary interest in that matter. Now, if they stand to benefit by a couple of cents on the dollar, that's probably not going to be so significant that it would require your disclosure and abstention. And it used to be that that was required under the ethics and government law, and the commission got a lot of cases about it's any pecuniary interest. So it could be a tax rate that benefited your property tax by a decrease of 0.2%, and it was nothing, but we still required you to disclose and potentially abstain on that particular conflict of interest. A couple of sessions ago, the commission said that's really silly. We're really talking about significant pecuniary interests in these matters. And so you may have a concern about what is considered substantial or not, and that might be the triggering question that you might want to bring forward to not only your public attorneys who are available to you, but the commission itself is also available to help you navigate those questions. Disclosures are required to be made at the time the matter is considered. For those of you who are in voting capacities, that generally means when the agenda item's been called, not after it's been discussed and vetted and then ready for action by the committee. It's when the agenda item's called. You have an obligation to say, Chairman or members of the public, I have a disclosure I'd like to make about potential interests I might have in this matter. And disclosure requires more than a simple disclosure of, I have a conflict of interest, I think I'm going to bow out and not vote on this. Your disclosures under the ethics and government law require you to disclose the nature and extent of your private interest that could be affected by the matter, and whether or not and how your vote on the matter could impact that private interest. And so the commission's had a lot of precedent that's developed this particular area of law, but what we're really trying to reach out and explain to public employees is that it really is a full disclosure. You're trying to inform the public of what it is in your private capacity that might be affected by what you're being asked to do in your public capacity. And that's what becomes really important for purposes of disclosure. I wanted to skip over to the definition of the types of relationships that constitute these conflicts of interest. And this was the issue primarily that Mr. Woodbury alluded to earlier that we went to the Supreme Court over a few years ago. You have a relationship with certain individuals, as I mentioned, and the interests of those persons are statutorily attributed to you. And those persons, those relationships include your spouse or domestic partner, any member who's a member of your household, any person who's related to you within the third degree of consanguinity. That's another mouthful. But that's by marriage, by adoption, by blood, any types of those relationships. We do have a chart that helps you navigate those types of relationships. It's just certainly not going to be your great-grandparents, but it's going to be your parents, it's going to be your siblings, it's going to be your children, things of that nature. And when we get beyond the the third degree of consanguinity, we might have other relationships that actually do fall within that category. Also is going to include persons who employ you, or your members of your household, or members of your spouse or domestic partner, and that's because you're financially tied to your employment typically. And so if your employer stands to benefit by a decision you might make in your public capacity, obviously you're benefiting your employer, which is going to probably presumably be looked upon favorably to you in your private employment status. And then finally, we have someone with whom you share a substantial and continuing business relationship. These could be individuals who are your business partners, or individuals with whom you engage in certain contracts, things of that nature. And then we have, and I'm certainly not going to call it a catch-all category because that is not what it is, but it was argued that it was a catch-all category, which is this end provision, which is that someone who would share a substantially similar commitment, interest, or relationship to one of these categories that's described above. And so where we get a lot of questions is someone who might say, well, he's a friend of mine. Do I have an obligation to disclose that the person appearing before me is a friend of mine? And the short answer is no. Friends aren't among the individuals who are captured in this statute. However, if you're going to testify, or if you're going to tell me that this friend of yours is your lifelong friend and you grew up with this person and it's like a brother to you, and you confide in this person more than your own sibling, and you would give your left arm for this person, I might say that that's the type of person who shares a substantially similar relationship to you as your blood brother. And probably that's the type of person that would create a conflict of interest for you. So sometimes these types of relationships are so significant to us that are not statutorily defined that might nevertheless create a conflict of interest in which you should probably disclose and maybe even abstain. The abstention provision, this slide's kind of funny. We try to reiterate, when in doubt, disclose the conflict, because you're better off disclosing it than having an ethics complaint filed against you and having the commission go through the entire process of having to put you through that. Abstention, of course, gets a little trickier. We get most of our questions about abstention and whether or not the conflict is significant enough to require you to have to abstain from voting. And the biggest reminder that I can give public officers who are in these positions is that the reason that you're elected to your position, the reason that you might be appointed to serve in the position that you hold, is because we want you, the public wants you to make those tough decisions. You're their representative. You're their voice. And if you're not making those tough decisions, and if you're not representing those individuals, you're not doing what they've asked you to do, and then you're not representing government. So we want you to always keep that principle in mind. So only in those circumstances where you have a clear conflict of interest, and that conflict and that decision that you're going to make is going to benefit your private interests in some way, only in those circumstances do we really want you to abstain from voting. And usually those types of conflicts are going to be pretty clear to you, hopefully. When they're not, again, you have your public attorneys available to bounce these issues off of, and you certainly have the commission to come to for the advisory opinion if necessary, or hopefully through my office we can sort of navigate you through maybe what the commission's decided in a relative area of that before. And I think that generally wraps up the bulk of my presentation. I don't want to overextend myself here. Are there any particular questions you want to ask? And please refer to the PowerPoint if you want specifics about some of the statutory provisions that I've discussed. One of the things I didn't talk about, and I certainly can, are our cooling off provisions. But as local government, that's not exactly applicable to you in all circumstances. So if you have those questions, I'd be happy to address those maybe at a later date. But if you have any specific questions, I'd be happy to address those at this time. Nope.
So you're saying if I'm the governor of Virginia and a pharmaceutical company wants to pay and caters my
I would hope that would be a very clear situation, which you wouldn't have to ask, but we would certainly be available to you. Yeah. You would. Mm-hmm. And, one of the things I did not share with you is that, of course, we're here to sort of be the public's guardian of how their resources are being used and how their representatives are behaving in terms of that conduct. But there are a lot of provisions that mirror ethics and government law that are criminal in nature, or that might impose other sanctions and other provisions by other individuals. And we do have an obligation as a commission to refer those issues that might have those standards in play. For example, accepting a bribe certainly might be an ethics and government law problem, but it also is a criminal problem. And if we have evidence and we learn of that conduct as we go forward, we have a requirement in our provisions to refer that issue to the appropriate district attorney or attorney general. And so there is that crossover. We certainly don't reach out into the realm of criminal law, but a lot of times the situations we see might trigger those types of issues. And we also, in terms of local government, and you may already know this, a lot of you, we have provisions that prohibit public officers from engaging in certain contracts with government. So if you have private businesses on the side and most often this kind of pops up in the idea of contractors. Contractors are often seeking public works contracts, and we do have provisions that prohibit public officers from doing that. But there are exceptions to that in the ethics and government law. But there are separate provisions in your statutes that make it a crime for certain local government officials to engage in certain contracts in which they have significant financial interests. And so when we give our advice about those contractual boundaries, we also say, but hey, we have no say and we have no position on whether or not you would be violating this statute over here if you went ahead and did it, even under our exceptions. And so those are the types of things you might want to be careful of that the commission won't advise you about.
A lot of what you talked about refers to public officers, paid officers. What about people who are on volunteer advisory committees? Is there a distinction between their responsibilities, the ethics law as it applies to them, versus paid public officers?
Sure. There is a significant difference. I think I mentioned at the outset that public officers in our provisions of law are specifically defined, and they do not include members of bodies which are strictly advisory in nature. And so, as I mentioned, the ethics and government law, we do not have jurisdiction over public bodies. We have jurisdiction over individual public officers and public employees. And so if someone's been appointed to an advisory body and they do not have any final decision-making power, we technically don't have jurisdiction over that person because they wouldn't be deemed a public officer within the definition of NRS 281A.
But with regards to open meeting laws, I mean, the operation of their board or the way they conduct the meeting, that should be subject to open meeting law, right?
Well, and I just saw George walk in a few minutes ago, and he's going to be coming to give that presentation to you, and I'm going to defer to the expert here, but yeah, generally, yes. Right, George? Yeah, yes. They would be subject to the open meeting law. Any other questions?
Question.
Sure.
What happens if somebody is found that
sure.
they violated
Sure.
an ethics law?
Okay. I don't know if you guys heard that question, but Adriana was asking what are the potential consequences for someone who has deemed to have violated the ethics and government law. And there's two processes that the commission goes through when it evaluates that question. It evaluates first whether or not the conduct violates a provision of ethics and government law. And if so, then it conducts a secondary analysis about whether or not that conduct was willful. If that conduct is deemed to have been willful, then the commission can impose monetary sanctions. Willfulness has been a pretty controversial subject over the last couple of years before the Ethics Commission and before the Nevada legislature. Most of us in our common sense approach to understanding willfulness think of it as malice or bad faith or trying to get away with something. But the definition in the law says that you knowingly and intentionally acted. And under the law in Nevada and elsewhere, that's a pretty easy standard to make. It means you did not accidentally approve the contract that would line your pockets. It means you knew you were going to do it and you intentionally did it. You may not have known that it would violate the law, but you intentionally entered into the contract. And so the commission found itself in a position where it was imposing willfulness in virtually every case that came before it where it found a violation, because they said, That's a pretty easy threshold to make. The commission almost thought that was a fairly strict liability standard where it really didn't have that much leeway in terms of imposing willful sanctions. And when it did, and it felt that there was absolutely no bad faith involved in the case, it would issue a sanction that mirrored what it thought on the level of bad faith. So we've had sanctions as low as $15 to kind of highlight, you know, this wasn't an intent to get away with the law and do something unethical and things of that nature. But in 2013, a bill was passed that imposed a review of various mitigating factors on the commission before it could impose a willful violation. And those mitigating factors involve, you know, whether or not you actually did receive financial gain from your action, whether or not you violated the law in the past, whether or not you relied in good faith upon your public counsel. And I do, if I have a couple more minutes, want to refer to that issue. And so the commission now, when it takes a look at whether or not the conduct was willful, it will take a look at all of the circumstances surrounding the issue, and it will also make an assessment about whether or not the conduct was done in bad faith or with reckless disregard of the law or with an intention to actually get away with something. In those instances, the commission would impose a non-willful violation with no sanction. The willful sanctions can be as much as $5,000 for a single willful, as much as $10,000 for a second willful, and as much as $15,000 for a third willful violation. If you violated the ethics and government law 3 or more times, the commission is required to move for your removal from office. The commission itself doesn't have independent authority to remove a public officer from office, so it would be, by example, referring the matter to the appropriate court, to the appropriate appointing authority for their decision about whether or not removal would be appropriate. But if we do have 3 willful violations imposed by you again from the Ethics Commission, it will be deemed to be malfeasance in office. And lastly, and I will conclude on this note, the biggest outreach the commission effort is trying to make at this point is also to get some outreach to the public attorneys who are asked to represent you, because they're your first line of defense in any question you might have about a conflict of interest. And the Ethics Commission simply can't be in all places at all times throughout the entire state. And the Ethics Commission, or excuse me, the Ethics and Government Law does have a safe harbor provision in the law which says that if you rely in good faith upon the advice of your publicly appointed legal counsel, then we're going to give you a safe harbor against a willful violation, even if they get it wrong. And so we always encourage you to talk first with your publicly appointed attorneys about conflicts of interest, sometimes even before you come to the commission, because if you've given them all of the relevant facts and circumstances and you're not hiding anything from them and they give you some good faith advice, then you're going to be able to rely on that and hope not to get a willful violation from the Ethics Commission.
Wouldn't you want to do that at the commission so there'd be a record of it being done?
Well, I think the short answer to that is that that may be appropriate, that you've relied on the advice of counsel in some circumstances, but more often than not, your legal counsel may or may not be prepared to answer a question like that on the record. So as much notice as you have to be able to give them the full set of circumstances, to give them an opportunity to evaluate the ethics and government law and how those conflicts might have been addressed in the past, is always going to be, I hope, appreciated by your public attorneys. But certainly that's a discussion you can have with your public counsel. Any other questions? Okay, well, as I mentioned, please hold on to your PowerPoint. It does have my contact information, and I'm always doors wide open to address any questions you might have. Thanks.
Thank you, Yvonne. And she seems very nice, but trust me, we do not want to be across the room from her in a courtroom. So thank you very much, Yvonne. Appreciate it. I did neglect to mention at the outset of this, Jennifer Mayhew has joined us. She is another deputy district attorney in our office, and she works in the civil division as well. She wears a few hats, but civil division is one of them. I'd like to introduce now George Taylor. Mr. Taylor has been a senior deputy attorney general for the last 25 years and spent the last 8 of them specializing as the open meeting law deputy. Prior to that, he did represent the Division of Conservation and Natural Resources in the Attorney General's office. So please help me welcome Mr. George Taylor.
So.
Do you guys need 5 minutes? You want to keep going? Keep going. All right. George, you have until
Hi there. Hey, it's nice to be here. There's a lot of folks here, and I'm happy to see all of you because sometimes it's just a few people that show up. But I'm glad I got here when I did because I wanted to use a couple of things that Yvonne spoke as a segue into what we're doing. There is a strong relationship between public records, ethics issues and ethics definitions, and things like that, and their opinions, and open meeting law. So I hope to bring some of these together, not to try to confuse you, but to enable you to make better decisions, and especially so that when you go to your attorney and ask him a hard question, be sure you give him a little bit more time than just asking him at the meeting. So that's important. I'm going to start there. Advice of counsel. And I have talked about this before. I'm going to make it real short because I'm going to be watching the clock. Advice of counsel is very important, but counsel does need a little time to make some decisions. And I know that in an open meeting, it's easy for the chair to say, okay, counsel, what's the answer here? Well, he may or may not know. She may or may not know. But it is important, and like the Ethics Commission, the Attorney General's offices, and our opinions in the past have put great store in the advice of counsel. It's not that it can't be overturned or gone back on, but we are going to look very carefully at that, and especially if the public body is making a good faith decision based on the advice of counsel. So I'm glad that she mentioned that toward the end. That was very important. Oh, okay. All right, I've got 44 slides here, but most of them I'm going to ask you to review them, and if I don't have enough to say about a particular slide, then look at it on your own. And please ask counsel whenever you have. They can call me, we can discuss it. I may not have the answer either, but when we put heads together and discuss things, we'll find an answer for you. And hopefully, at the end of this and the next presentation, there will be a time for questions if anyone wants to stick around for that. Definition of public body. Well, I presume from looking at your agenda that you're all members of a public body. Perhaps some of you are staff, especially staff that works with a public body. If you put together the agenda, I'll put together materials for the agenda. So is that correct? Is there anybody here just off the street and was passing through and decided to come to an open meeting law? No, that doesn't happen, does it? So, okay. Well, I usually ask. It's going to happen one of these days. I'll probably be in Ely at the time, maybe Elko, somewhere like that. But public body, so you're all a public body. There's a couple of definitions. This is found in 241.015 and paragraph 4. So we're going to keep going. But this is a good slide. There are 3 requirements for a meeting. There's got to be a quorum of the members of a public body, which is a majority of the members. That's the general definition of quorum. Then the public body, the quorum of the public body, or the entire public body has to deliberate towards a decision. And secondly, action, which means taking a decision. It doesn't require deliberation and action. It can be either or. You can be deliberating. Quorum can deliberate and be subject. It's a meeting, whether you take action or not, whether you table the matter and do something else with it. In the last session of the legislature, an important change in the law occurred, and that is they modified the definition of deliberation, which we have used from California case law, And they removed a part of the case law, and I think this is in favor of public bodies. Right now, the definition of deliberation is in the statute, and it includes the collective discussion or the exchange of facts preliminary to an ultimate decision. In other words, a vote. What they took out was the fact-finding. And heretofore, the California court had always, one that we had followed, the definition, said that fact-finding was also a form of deliberation. Well, the legislature made it clear that's no longer the case. Action has always been defined in statute, and it means simply voting, but it also includes making a promise or a commitment. And that could occur during the meeting, that could occur outside the meeting, but a quorum's got to be involved. So action is an affirmative vote by a majority of the members. But by the way, how many of you are new to the open meeting law? How many of you have never served on a public body before? Two folks. So we've got some veterans here. So I can speed this up. Does it go faster? Yes, you can ask questions, of course.
Quorum of those present or quorum of the members, the total members of the body?
If it's an advisory body, if it's appointed, then it's a quorum of those present. Yes. If it's an elected body, a quorum is a majority of the elected members. It's a different way of determining the quorum. So we've got what there are seven, the supervisors, are there seven? Five. So you always must have 3 members here to transact any business for a quorum. But an advisory body, if 4 members shows up, then the majority of those, 3-1, could, or if 3 members show up, they could vote 2-1 to take action. So, next, a fundamental agenda rule is that all items must be clear and complete on the agenda, which means that the person passing by who wants to see what the open meeting law is all about, if he read an agenda, he's got to understand what topics will be discussed tonight or that evening. And we're going to have a couple of examples coming up. This is the site for a Supreme Court decision which discussed this, made it clear that clear and complete means that it's something that a reasonable person would understand, and that's the topic that will be discussed. It rejected the so-called germane standard, which is, okay, we're talking about a zoning issue, and then the board might meander into a mining issue that's related to it. Well, the court said, no, you can't do that. If you're going to talk about mining, it's got to say that on the agenda item. How to comply with the clear and complete rule. How many of you write agendas, do minutes, do staff work for sure? Make sure the agenda provides a complete list of topics to be considered. The items must be given clear public notice. And related matters may not be discussed or the public body may have strayed. So here's a couple of examples. Many public bodies have used the following phrase on their agenda, and all matters related thereto. So my office always recommends not using that phrase for any reason. If you don't know what's going to be discussed, then you may have to wait till the meeting, and then at that time, if something new comes up, you may have to re-agendize it for a future meeting. There was an agenda item announcing negotiations on a new city franchise for waste disposal. In part, it stated the public body will address general issues relating to this franchise for the removal of waste, including, quote, special provisions for inclusion in the new agreement. Well, it didn't say what the special provisions were. So we reviewed the video, and it had been there had a motion been made to direct staff to include mandatory trash pickup, mandatory trash service as a part of the bidding process for this franchise agreement. The Nevada Supreme Court had addressed this already, and they found that a higher degree of specificity is needed when the subject to be debated is of special or significant interest to the public. So we found that it was a violation because they didn't do that for the public in that city. Public body did cure that violation at the next meeting. Stick to the agenda. Members and our council must prevent the public body discussion from wandering off topic. And this is related to a clear and complete, and it's related to the germane issue. And I apologize if these are fundamental issues most of you are well acquainted with, if you're a veteran of a public body, but it's probably important to be reminded of this. And it may generate some facts in your mind and ask some questions either now or when we're done with the training. Here's another example. The Board of Regents. Here's an agenda item they used one time. Quote, review state, federal statutes, regulations, case law, and policies that govern the release of materials, documents, and reports to the public. That was the extent of it. So far, so good. The board strayed from the topic despite warning from council. The regents discussed details of a Nevada Division of Investigation report into an incident on the UNLV campus, criticized their police department, commented on the impact of drug usage, and other matters. The council warned the board that they were straying from the agenda on several occasions. They did not stop. The Supreme Court opinion said, no, this is germane. The agenda did not inform the public that these matters would be talked about. The court rejected the germane standard. This is Sandoval versus Board of Regents. So I went back a slide. So here is the agenda item. Review state and federal statutes, regulations, and case law, et cetera. Well, there's nothing in there that said that we're going to also talk about a police investigation on the UNLV campus or drug usage and those kinds of things. So I think that's a glaring example, but I think there are lots of other examples that we deal with every day in your advisory bodies, your supervisor meetings or whatever. It doesn't have to be this glaring. It is sometimes very easy to stray from an agenda. So, now, here's a little bit of good news. Openness is the norm, but, and it should be liberally construed and broadly interpreted. Well, and our court has done a pretty good job of that, in my opinion. There's only a few opinions that have resulted in a complaint about the open meeting law, but the court does a pretty good job on it. However, the good news is the OML does not prohibit every private discussion of a public issue, or even forbid lobbying for votes, but a quorum must not be involved. Nevada is a quorum state. It's very, very important to avoid a quorum in your conversations, getting more than one member of your body to talk with you. And there is a citation to a Nevada Supreme Court decision in 1987. This can lead, when you're talking, you're privately discussing matters with members of your advisory body or your elected body. Serial communication amongst a quorum is prohibited. Now, serial communications can be attained either through speaking with them physically, at a meeting, or with the use of electronic media, cell phones, smartphones, laptops, any kind of computer. And the way that happens is perhaps you want to speak about something that happened at a meeting with another member. Well, that's fine, as long as two of you is not a quorum. But if one of them uses a smartphone, like that gentleman on the left in the slide, using a telephone to call someone else and say, hey, we were talking about the zoning issue tonight. I don't think we made the right decision. What do you think? Can you see that happening following a public meeting? And so that's how a quorum can be attained. Yes?
Just a little clarification. So to somebody and then have a conversation with another single person on the board and then another single person without referencing the other conversations. But you can't go around one by one. And
Well,
maybe
that's a factual.
feel out where they're going to vote, you know.
Yeah, lobbying for
before you get
votes.
to your meeting.
I think not. However, I think that if you do go person by person and you exceed the quorum limit, even if you haven't told the other person that, or any of the other people, that there is yet another person behind there that you've also talked to, I don't think that's a good idea. I have not investigated anything like that. Almost every instance where we have investigated matters involving a quorum and a serial communication, everyone knew that someone else was involved. That would suggest that that's a willful act, you know, and going behind, avoiding the open meeting law in a willful manner. And remember what Yvonne said about willfulness. I mean, there are definitions in their opinions about willfulness. And our opinions, our statutes require knowledge. Participation with knowledge is the basis for the Attorney General's authority over the issuance of penalties and litigation, I suppose. So participation and knowledge is not too far removed from what she was talking about, willfulness. A committee or no committee, I think when looking at this agenda, a lot of these are committees or subcommittees, right? Probably all of them, though, serve at the pleasure of the Board of Supervisors. So they're appointed by the Board of Supervisors. And this says, in our opinion, regarding whether it's a committee subject to the open meeting law, is this: to the extent a group is appointed by a public body and given the task of making decisions or recommendations, then is subject to the open meeting law. And here's another, I'm just restating it again on this one. If a subcommittee recommendation to a parent body is more than mere fact-finding, because a subcommittee has to choose or accept opinions, or decide to accept certain facts and discard other facts, or if it has to make any type of choice, then yes, it has participated in the decision-making process and is subject to the OML. Anybody have any questions about that? Because that's usually a hard one, especially in the rural counties, where, well, like this, local government does depend heavily on committees and subcommittees to do a lot of work, a lot of heavy lifting. So it's important to know what you're subject to, what laws you're subject to, including ethics, public records. Hopefully, you know, you'll get a good discussion from Sarah when she gets here. Now I'm going to move on to another topic, public comment. Constitution is not a sunshine law. There's no constitutional right to speak at a public meeting like this. And there's some issues, some reasons, and some citations. However, once a person is given the right to address a public body, that right may be limited only within constitutional parameters. In other words, First Amendment case law. First Amendment, currently the OML authorizes a public body to do these things. These are restrictions that the Ninth Circuit and to some extent the U.S. Supreme Court have allowed, but primarily the Ninth Circuit. In a limited setting like this is not the sidewalk, this is a limited public meeting place. The public body may restrict public speakers to subjects within its jurisdiction and its control or advisory power. It may limit public comment if the speech becomes irrelevant or repetitious. Usually the chair will say, you know, we heard that from the last speaker, or you're repeating yourself. You know, if you have something else to add that we haven't heard before, please say it now. The public body may apply reasonable time limitations. Doesn't mean it has to be 3 minutes. Depends on the size of the meeting. If there are a lot of people here to talk at a supervisor's meeting, they may decide that 2 minutes is enough, because if they want to give everybody a chance to speak, then they can adjust it. But it has to appear on that agenda. The restrictions are not something that can be announced at the meeting, but the reasonable restrictions, public comment restrictions, must be on the agenda. And most public bodies have used the same one until they've decided that some special event requires a change in the conditions, and which is fine. That's what you can do. What a public body may never do is limit public comment based on disagreement with viewpoint. Subject matter, yes, but viewpoint, no. Viewpoint is perhaps political in nature, just disagreeing with the direction that the public body is going, the action that they're taking. Public body has got to listen to it. It's got to hear the public comment.
Back up one, you didn't touch on limiting costing.
Oh, personal attacks. Yeah, I'm sorry.
And really where I want to go is, when does it become personal and when is it against the group? When does it cross the line?
Well, I think that's a factual issue. If a person is pointing someone out, singling someone out on the board by name, then that's a personal attack. But to the extent that it isn't the entire board, then that runs the risk of being a disagreement with viewpoint. So it's got to be, this is a really hard area of the law, and there's been a lot of litigation in federal courts regarding this very issue. Restrictions on public comment. When can you ask someone to leave? When can they be escorted out?
George?
And we're going to find out about that.
It is a very subtle line, and would you recommend as a practice if the chair of a body is inclined to shut some public comment down, should the advice of counsel be sought and indicate, look, I'm thinking that this is going into a personal attack, I'm inclined to shut it down, give me some advice here. Mm-hmm. Is that a good practice? Is that something they should do?
Let me go to the next slide, and I'll answer that question with the next slide. Here's some public comment pitfalls, but I want to say this, the Ninth Circuit law requires an actual disturbance. So, yes, to answer the question, his question, yes. Once we understand that a person can't be removed unless there's been an actual disturbance. Now, I don't mean I don't mean it's got to be fisticuffs or something like that. An actual disturbance can be just simply raising one's voice and arguing with the board after the chair has told him your time has extinguished. You need to sit down, and he won't do it. So if the body has been disrupted to the point that its orderly conduct has been made impractical, then they can be removed. The hurdle is very low in the Ninth Circuit. I mean, it's amazingly low. Yes?
Are you saying that if the chairman doesn't like the tone of voice of somebody speaking, they can tell them to stop and to leave?
He certainly may do that, but whether that's legal under the open meeting law, this is another issue, because what's an actual disturbance? It requires, in the Ninth Circuit, a willful disruption. And the Ninth Circuit has seen so many of these, and I keep saying Ninth Circuit because all of these Nevada cases and Arizona cases.
There recently a U.S. Supreme Court decision on this very issue.
I'm not aware of it.
I don't have it here to cite, but I don't know.
So in any event, willful disruption, so there you go, willful, knowledge. All of these issues that are defined in the statutes, in the ethics statutes, and in the open meeting law statutes, and those need to be mastered and consulted. But it does require disturbance, and not just because the chair feels like their tone is being offensive. It takes more than that. It's got to be an actual disruption. Public comment. This has been changed in the last two sessions. Most elected bodies use the second alternative, which is public comment must be heard before a public body takes action on any matter, but only after it has discussed the matter. And the public body must allow one more period of public comment before adjournment. Now, advisory bodies frequently choose the first alternative, which is just simply 2 periods of public comment on each agenda. But the legislature carefully said that public bodies may augment either or both alternatives with additional opportunity to comment. Public comment is really a big part of the open meeting law, transparency in government, whatever you have it, and to manage public comment well is quite a skill, because these things can erupt at any time. Let's see. There are notice requirements. No doubt you're familiar with these. But the last bullet says public comment restrictions must appear on each agenda. Serial briefings are not meetings. This is Supreme Court case law. So when staff meets with less than a quorum of a public body, that's fine. That's considered a serial briefing, and it's not offensive to the open meeting law. But stay away from a serial quorum or walking quorum or constructive quorum by involving yet another member in the manner we just talked about a few minutes ago. Remedies if violation occurs. Some of these were just recently added by the legislature to the open meeting law. We have the ability to go to court and seek to void an action and/or seek injunctive relief. Corrective action was just added last session, and it has come to play a big role in a few cases. Corrective action means that a public body, before adjournment, may choose to correct some action or something that happened at their meeting before adjournment and avoid a violation. That was put in the open meeting law in just last session in 2013. We've always had a criminal misdemeanor statute. And then last session or 2 sessions ago, civil monetary fines have been added, and we were given subpoena authority for materials, for the production of relevant documents, records, or materials in any investigation. Willful failure to comply may result in prosecution for a misdemeanor. Now, the good news is, since 1960, I'm not aware of, and I've asked other folks in my office, that we've ever prosecuted anyone for a misdemeanor under open meeting law, for a violation of the open meeting law. We've told the legislature that. So what the legislature did, okay, that's fine. They went back and gave us civil monetary fines. They went back and gave us the corrective action statute. We told them that we felt like this would be, these kinds of incentives, if you will, would be more in keeping with the nature of public bodies and still keeping folks like you interested in serving on a public body. So penalties, I'm going to leave these, let you look at them, because I want to get to, I better talk about this. We were asked in one of the legislative committee meetings what this meant. Enforcement based on participation. And we actually put this in writing, that a violation can only occur when a member makes a commitment, promise, or casts an affirmative vote to take action on a matter when the member knew his or her commitment or vote was taken in violation of the open mail. So it requires knowledge. That's a pretty high standard. More about how to avoid a civil penalty. Action is required. Mere silence or inaction by members is not sufficient to rise to the level requiring enforcement. This office, meaning the Attorney General, would not seek to punish individual members, only those who actually violate it. There's the manual. Then, I know I've only got like 2 minutes to take, but this is something that I've been giving to a lot of public bodies. This is how ethics, this is how public records and open meeting law, one of the areas that we rub shoulders with. that this impacts everybody. I put this together for the impact that using your smartphones in your meetings for public business, or even at home for public business, can impact your open meeting law, your duty under the open meeting law. So are you a public officer serving on a public body? Well, as Yvonne said, if you're an advisory body, they're not considered public officers. Didn't I hear you say that?
That's true under the ethics and government.
Just under the ethics and government law. But so let's put that aside for the time being. Right to privacy is where all this comes from. FOIA requires federal agencies to make records available, but there was a big snafu in the Congress last year, and where the requester asked for a lot of agency records. It was limited to higher ups. It was found then, or assumed, that they were using their private smartphones to conduct agency business and avoid FOIA obligations. So this is still going on. I check on this for a while, and these cases are still open, and it's Landmark Legal Foundation, August 14 of 2013. And then currently, I just put this in, and here's Hillary Clinton. She's in the news about the emails and using her own private server, to conduct public business. So I'm just saying all this to raise consciousness, because the law in Nevada, there is no law on the use of private cell phones, smartphones, and so forth. But I think that you need to understand that a lot of states have gone through this and have adopted some rules. For example, this is an Illinois case where a reporter asked for all electronic communications, including cell phone text, messages sent and received by members of the city council and the mayor, blah, blah, blah. And this was in 2013. In Illinois, this is what happened. An Illinois appellate court found that communications from personally owned electronic devices during council meetings and study sessions were subject to disclosure under FOIA as a public record. Illinois public record is defined as, and there's the second bullet. The third bullet, public record is not defined in Nevada. I would argue that it's not formally defined. However, NRS 239 says, unless otherwise declared by law to be confidential, then all public books and public records of a governmental entity are subject to inspection. Another example in Pennsylvania, then this one, school board members. Email records that did not document a transaction or activity of the district were found not to be public records. But it also said that locations of the emails on an agency computer didn't provide a lot of protection for you. And the third bullet, an individual school board member acting in his official capacity constitutes agency activity when discussing agency business, implying that it is subject to a records request, regardless of where the email is found, whether it's on an agency-issued smartphone or laptop, or a personal smartphone or laptop. So, now the rest of this is Nevada law. There is no Nevada law on these issues that I've been able to find, and all I did was put together a couple of things. Here's DR Partners, Reno Newspapers versus Sheriff, and then Jim Gibbons issues. But none of these speak to the issue I was just trying to get across, which is, if you use your smartphone, or before you use your smartphone or your laptop at home to do public business, talk with your counsel. I'm not saying that this is illegal or anything, but you can see that some states have been asked to determine these things. And I also wanted to say, last thing, I'm just 5 minutes over, but I think the Supreme Court of California is going, it's been teed up in California. And it was in June of last year, The Supreme Court of California accepted a petition for review of a case entitled City of San Jose versus Smith. And it has to do with California Public Records Act. Required disclosure of private voicemails, emails, and text messages relating to city business. So this has been teed up over there. I checked just a few minutes ago, nothing yet. But I'm hopeful that they will weigh in on this and give us some direction, one way or the other. And I'll provide this to you. I didn't put anything on there. Yes?
Getting back to the open meeting law in Nevada, I just want to clarify, isn't it true that
Sorry.
so if you take 90 days or so,
Or that person could go directly to court, which has happened. Once they understand that there is a limitations period for voiding an action, then they may get nervous and just go on to court, and that has happened before. Mm-hmm. Hey.
Hey, George. Yeah, speaking of open meeting law, so basically what you're saying is that everything
Well, it would seem like that would be good advice, yeah.
Yeah, question on the quorum, so, Carson referenced people, but the quorum is 5 or more. If there's 4 people, you know we can't conduct business, but we have taken a vote on this and that, that's.
Well, I don't know if that's correct or not. We've allowed that ourselves too, but talk to council and see, what they think, whether that's something that they want to allow across the board. I don't know. But, there's not a quorum.
What about a FOIA request from a newspaper journalist wanting private emails of advisory committee members discussing advisory committee business?
Well, that comes down to some of the cases I was looking at. Of course, all the cases I had up here were elected members of a public body. Now, what happened? Did you get a FOIA request?
Almost.
Almost. So.
Yeah, I kind of deflected.
Okay. Well, I would just be supposing what might happen, and I don't want to do that. So, but I would love to hear of a case where a FOIA request was given to a member of the public body because of their use of their emails and laptops. I'm just not aware of any in Nevada. Okay, good. All right, that's a good segue right here. This is Sarah. I'm going to get out of your way. Sarah, maybe you could start right there. You said you were aware of one, so that would be a good place for you to start, huh? I want to hear that too. Thanks, Jason. You bet. Thank you.
What we'll do is, if we can just go ahead and take a 5-minute break. I don't want anybody to miss out, and I want you to not be uncomfortable either. So we'll be back in 5 minutes at about 3:12, 3:13. Please take your seats again. everybody. Sarah Bradley is our next presenter. She's a Deputy Attorney General, currently working in the Boards and Licensing Division of the Nevada Attorney General's Office. She has been a Deputy Attorney General here in Nevada for 8 years, the last 3 of which she has spent being involved in work in the area of public records, which she's here to talk about today. Before working in the Attorney General's office, Ms. Bradley worked in Ely as the clerk for District Court Judges Steve Debrescu and Dan Papez in the 7th Judicial District Court of the state of Nevada. So welcome, Sarah, and thank you very much.
Okay, well, if we want to go back to the question we had just before the break, I don't know if that person is still here. Oh, there she is. I see her. Recently, we had a request, one of my clients did, for emails that were sent from board members to the executive director, from private emails that the board members maintained to the executive director, and it would be considered public business, government business. So that was provided to the requester. I'm also aware of a time when there were text messages. This was several years ago, but the executive director was texting the board president, who was in Las Vegas during the meeting, mostly about, let's move on to this item, or are we going to break for lunch, that kind of a thing. And there was a request made by one of the people present for the text messages in that case. I'm not sure, I don't remember if they were provided. I do know that an open meeting law complaint was filed in that case, and George did not do the investigation. I believe he was considered conflicted out because our supervisor, because we work in the same division, was also present at the meeting, and so someone else reviewed them. I don't recall if those messages were given, but I do know that request did come, and I think George is right to alert everyone and all of us to think about these issues, because even if it's our personal, whatever it is, Kindle, iPad, all of those things, if we're doing work business on it and we're housing work business on it, it can be open. So one thing we do in our office that I think helps, I don't know how your emails are maintained, our emails, like for example, when I access my work email on my personal phone, I'm logging in, I'm looking at it, but I'm actually not downloading anything. So everything's still on the AG server. So I'm at least not commingling my emails. So if someone wanted them, they're all still, available on our server. Same with our calendar. My calendar, essentially a copy of my calendar is added to my personal phone so that I know where I'm supposed to be. But again, the official record is housed on our server, and then my personal appointments I put on my phone myself. And again, we don't have a commingling then, but when I look at it, it's one view. I can tell, of course, the sources. So I don't know if those are things that would help, but certainly I think we want to be careful about that, because the Hillary Clinton issues, I think, have highlighted that this is something that's going to keep being discussed, I think. And we have had requests in the past, as we know, for the previous governor's emails, and so these are things that people sometimes do want to know. And there actually also is a case from Washoe County regarding county commissioners. In that case, though, it was state paid for cell phones. And of course, they said those records were public. But that was one of the first times I think those things were looked at, was what do we do with these? Who called them? Who knows that kind of a thing. So I will start with my presentation. I was trying to give you an overview, because really, it's so fascinating. We could talk for 3 hours, but I know you only want me to talk for 30 minutes, so that's what I'm going to try to do. I've given you some slides in here just for reference. A few of them I'm probably not going to talk about much, but they're just for you to have. So the overview, Public Records Act is in NRS Chapter 239. The general principle, all records are public unless declared confidential by law, and open government is the rule. There are also regulations that accompany the NRS provisions, so you may want to look at those from time to time, and that would be the NAC 239. There are some definitions and other things there that are helpful, and there are some new provisions. So new regulations not yet codified. They don't actually apply yet to local governments, but they could be helpful for those of you responding to requests. They talk about things such as, what do you do when a person requests documents, you make the copies, they're sitting there, when can you throw them away? Well, a new regulation says after 30 days you can throw those away. So again, it doesn't apply to you as local governments yet, but it could be helpful guidance for you if you're having questions. So again, general premise here, all public books and public records must remain open. We now have a big long list in 239.010. of all of the confidentiality provisions. So all of them are listed there, and then there's this catch-all, unless otherwise declared confidential by law. If you look in this session's bills, which I have tried to do, many will come up now as public records bills if you're looking for 239 changes, because any one that has a confidentiality provision is being added to 010. So it looks like they're going to keep that, which is great, but it does make it hard when you're trying to determine what new legislation is really coming to affect how we do things. NAC provisions are not included currently in the confidentiality list in 239. However, we have a Supreme Court case that tells us that a properly adopted regulation has the force and effect of law. So regulations, if there are some that are applicable to what you're doing, should also be appropriate. There is an Attorney General opinion, I believe, that says that ordinances, though, which I know probably a lot of you use, are not the same. So they're not considered a confidentiality provision for this purpose. So if you have those issues, talk with your legal counsel, I think. And they, if they have questions, sometimes I have local governments call me, and I'm happy to talk with them about that. This is just a list for you of court decisions, just because I thought some of you, may want to read them at some point. I find them fascinating. So if you look, it's kind of interesting to see the trend. We have 3 cases that are older than 5 years, and all of the rest are new, relatively new, within the last 5 years. So you can see there's a lot of kind of movement, perhaps, in this area. The most recent case was actually decided March 5th of this year, and it's an interesting case to read, I think, especially from a local government perspective. It's Las Vegas Metropolitan Police Department, and it's talking about whose record it is and who has the obligation to provide it. And it was pursuant to a contract that Las Vegas Metro had with a third party. And Blackjack Bonding wanted those records. So what we have seen in the last 5 years, essentially every time the court has said the burden on the government agency in holding back the record is harder and harder, higher and higher. So that's kind of the trend that we're seeing. So again, the MPRA favors transparency in government, and we have to liberally construe exceptions that say that things are confidential that has to be construed liberally in order to maximize the public's ability to access records. So that's what the Supreme Court's told us based on what the legislature has put forth for us. The case there that I'm citing is actually the Governor Gibbons email case from 2011. And then again, from that same case, there's this idea that open government helps democracy, makes things better, the public's paying for us to do things, and they should know what we're doing. I mean, that's the idea. And so I would always encourage you to do that. This is kind of the leading case, Don Ray of Nevada versus Bradshaw, or at least it started things in this area for the most part. So we call it the Bradshaw balancing test. That's what the Supreme Court calls it. And so you might hear attorneys say that probably a lot. They'll say, oh yeah, we've got to do the Bradshaw balancing. So what that means is if there's no confidentiality provision, okay, nothing expressed in law or regulation, and you still think, this is a dangerous document. I just don't think we should release it. I have some reasons, maybe it will endanger somebody, or there's just something that I'm concerned about here. The court says you have to do this Bradshaw balancing test. So you have to balance the public's right to access it, which again, they're saying is very broad. So that's a high burden, and your concerns about releasing the document. So generally speaking, again, in recent cases, the court hasn't been very favorable towards a balancing wherein the agencies have not provided the record. However, that doesn't mean that you should, I think, provide everything that's asked for just because of that. I think you want to be careful. You want to talk with your legal counsel. Yes?
I'm sorry, I was involved in that case, and actually what the court suggested was that the court itself was better at making the balancing test. Wouldn't you advise the average public employee to consult with the DA's office before they make a final decision on releasing other documents?
absolutely, you should always consult your legal counsel. However, after the Bradshaw case and the next case, the court said that Bradshaw balancing is required. It's not an option. So if there is no confidentiality provision, you must do this test. They had kind of left it a little bit vague initially in the 1990 case. So the Bradshaw balancing is required. Absolutely consult with legal counsel. However, as you'll see in NRS Chapter 239, the good faith immunity that's available for a mistake is available to the public officer or employee. So you guys are in a unique situation because you have legal counsel employed by the city. So they're employees as well. But generally speaking, the public officer or employee with consultation with attorneys should make the choice. It's not a choice for attorneys to make. So attorneys should not be routinely saying, this is confidential, this is not, that's not, we're supposed to help guide you and talk with you about it. Things, like I said, are a little different at the Attorney General's office because many of the state agencies we work with do not have attorneys on staff. So we really truly are a legal counsel outside of their office. I've had people ask me this question on the local government level, and I'm not sure how a court would rule on that. We don't have case law on that, but the way it's worded in the laws, it said the public officer or employee. And I believe the implication is for essentially ground level, those people in the areas. And if you make a mistake, either releasing something you shouldn't or not releasing something that you should have, there is a good faith immunity for that. So then later in DR Partners, and this is where the court tells us we have to do the balancing test in Bradshaw, it's not an option. And in this case, the court talks about a fundamental right of the public to access records. And so probably lots of us in the room know fundamental rights generally mean religion, free speech, those sorts of things that the U.S. Supreme Court has said are fundamental rights. But in Nevada, at least, the Nevada Supreme Court seems to kind of, it doesn't say it's equal, but it certainly uses that same phrase. And so to me, that means we know this is very important. They're going to treat it very serious, and they want those released for the most part. So again, there's a burden on the government. It's a high burden. It's gotten higher and higher, in my opinion. And you have to have specific evidence that justifies the withholding of records. So what the court wants is not something that's speculative or hypothetical. If you say, for example, to legal counsel, you get this request and you say, okay, I can't find a statute. I don't have a reason that says I don't have to provide this, but I'm just really uncomfortable. I think, there's a potential for some sort of problem here. You want to articulate that with the legal counsel and talk about it and perhaps do that balancing test. But one thing the court has told us, they want more than just a hypothetical concern. They want something actual. And verifiable, specific evidence. So again, it's a high standard, and I'm starting to wonder, just looking at the recent cases, what would meet that burden, because I don't completely know, and I'm sorry that I don't. So this case was a case, this Reno newspaper's case. Basically what this case tells us is just because there's confidential information in a document does not mean you don't provide it. Instead, you should redact and then provide it. That's basically the rule here. What happened was there were some amendments in 2007 to the law, and what the people were asking for, the newspaper was asking for in this case, was post-concealed weapon holder permit, I think revocations and other background checks done after the person already had a concealed weapon permit. So I don't completely understand how that process works, but essentially they wanted, criminal information, other kind of sensitive documents that may have been a part of that. And so initially the Washoe County Sheriff said, no, we're not going to provide it, it's confidential. And eventually the court said, the rule here I have at the bottom, whenever possible, redact and provide. Just because there's something confidential doesn't give us the right to hold it back. I've given you a list there underneath of some things that you should probably for sure redact. Again, check your statutes, check your regulations, talk with your legal counsel. There could be other things that you should redact. This is just sort of some examples. I have clients that have statutes, for example, that say home addresses of licensees are confidential. So if you have a statute like that, of course, home address should be redacted. Yes?
Sarah, what about just deleting the last 4 digits of a social security number?
I think you can do that, and lots of people do for identification purposes, if you're using it as an identifying number. I don't know that there's a problem with that. But it is defined as a confidential, I mean, the whole number itself is defined as a confidential piece of information, and that's in actually NRS 603A, so that's a helpful reference to occasionally look at. 603A, and then there's 239A and 239B, and then the regular 239 that we're talking about. Yes?
I'm surprised to see date of birth on there, because we give the date of birth out all the time on all of our documents.
I think date of birth in conjunction with the person's name and/or social security number. I mean, what we're looking at is this something used to identify them for, and it could be used as identity theft. So I guess I'm not sure what type of marriage certificates. Okay.
Issue with giving out all that personal, right now, if anybody wants a copy of it,
Yeah. Yeah. Well, I would talk with your legal counsel about that and see what they have to say. There are provisions. It's an interesting area. I wish the legislature has given us a clear definition of what is confidential and what should be redacted. When you do a search for that, you have to kind of go in multiple places. And so there are statutes that say date of birth. There are none in 239 though, unfortunately. So I'm kind of going all over the NRS, and I actually have a list. But there's criminal statutes, there's multiple places where they talk about what is confidential in certain times, but nothing really across the board, if that makes sense. So I've given you what I think is kind of a summary. Credit card numbers should be redacted, bank accounts, those sorts of things if you have them. I would think, my thought would be, date of birth in conjunction with the name, I think you could make that argument that should be redacted. But again, if the person is wanting a copy of their marriage certificate, that might be different. So, I'm not sure. Talk with your legal counsel if you have those questions. So again, high burden on government. When you do the balancing, the government's interest in holding the record back has to clearly outweigh the public's right to access. And they don't want hypothetical concerns. Again, looking at the 2011 Reno Newspapers versus Jim Gibbons governor case, one of the things this case told us is that internal policies don't have the force and effect of law. So one of the things that was argued in this case was that email policies have been adopted by the state, and these email policies should say what we should do with the records and how it should be handled. And the court said no. And part of the issue in this case was they still had records. Emails and other correspondence are categorized in certain ways, and so one of the categories is transitory, which would be like, do you want to meet me for lunch tomorrow? That would be transitory. After you don't need it anymore, you can delete that, and you should under the state records retention schedule, because it's not needed. It's not really a state record that has a life that should be preserved. Routine correspondence is a 1-year retention, and then official action or official, more executive level would be a 4-year retention. And then there's this related correspondence idea, which is things like, for example, emails or letters related to something else that has a retention schedule. Let's say a legal research file that you have to hold for 5 years. Your related correspondence would be held for 5 years with that subject. So essentially there's 4 categories, and in this case some of the emails were transitory, and they said, well, we don't want to provide these, they're not really a record, and we don't have to have them anyway. But part of the issue here was they did have them. And so the court said, well, that's nice, but you have them, so you have to provide them, regardless of what the policy says. So I think if you're following your records retention schedule and your policies, I think then you're protected when somebody asks for your record and you say, hey, we don't have it, we destroyed it under our policy. That is fine. But the issue is you have to provide it if you do have it. And if you have an internal policy that says these sorts of emails are confidential, that's not going to hold up as a protection against giving those out. If you're going to keep something back, you need to let the person know what you're keeping back and give them a reasonable idea of what's included. It's kind of a balance here. You don't want to give away what you're saying is confidential, but you have to tell them enough so that they know this is what's being held back, here's why, in case they want to challenge you. Okay, so that's what they're talking about in this case about a log. They don't want a boilerplate of citations, so you really have to articulate. We've done the Bradshaw balancing test. We're concerned that if we release this information, it's going to, cause this certain problem. Sometimes, too, one thing I think about, and I advise my clients, and you might think about, and your legal counsel you might want to talk with about, is there's a difference sometimes between temporarily holding it back and permanently holding it back. And so what I mean by that is there are generally exceptions for if you're working on a contract and people want to know how much are you willing to pay. Well, clearly, if you tell them that ahead of time, they've gained an advantage in that process that maybe you don't want them to have. So generally speaking, the state or a local government, if they're entering into some sort of negotiation like that, can hold back some of that information, like, for example, your bottom line that you can pay, until after the contract's awarded. And so then you would release maybe your notes on that, or the memo from, the mayor, or however that's disseminated. And so I always think to myself, there's a harder burden on you if you're holding it back forever. But if you're holding it back temporarily because the government is trying to get something done, like make a decision, award a contract, something like that, I think you're in a different position. I think the scrutiny won't be quite as high from the court. So here's a recent case we had end of 2013. The court, again, tells us we have to construe conceptions narrowly. This is kind of an ongoing theme over and over. The state has the burden. And what's interesting about this case, and what I guess I find maybe concerning, so in this case, the newspaper asked for information from PERS, and PERS was concerned that releasing this information could cause identity theft and other concerns. Apparently, though, they weren't asking for Social Security numbers. I think they were asking for, names and maybe PERS payment amounts, So the PERS said, hey, look, we don't want to release this. We have this other provision that says it's confidential. Some of the same information was housed in other places. And so the newspaper said, well, okay, fine. The database is confidential, but this other this other stuff is not. And so the court said, the fact that Nevada was the third leading state in fraud complaints and the sixth leading state in identity theft, that still didn't meet their burden in holding it back. And so it seems to me, at least based on this case, you'd actually have to show harm. Like, somebody's identity was stolen because we gave information out on date X, right? I mean, it almost feels like that's what they're telling us. And so I find that a little bit concerning myself, just because we don't want to have harm before we can show them we have harm, at least in my thought. But of course, they're saying they don't want us to hypothetically make things up to withhold records. So that's kind of, I think, where they're erring. Go ahead, yes.
Yeah, I just have a quick comment on that, and that is, as a PERS participant, I guess I was worried that it would be like my bank account, or like my bank deposit total posted. I wasn't told that my bank deposit.
Yeah.
So, I mean, I treat that as an account.
Mm-hmm.
So just.
Yeah. Yeah, I mean, it's my understanding that they weren't asking for Social Security numbers and dates of birth, things like that, but they did want financial information regarding individual folks that are retired. So. In that case, the court looked at and kind of left us with the question about whether there's a duty to create records or not. And we have a recent case, the one that was just decided a few weeks ago. Basically, the rule is the agency doesn't have the duty to run around and compile maybe hard copy records based on things you may have in your office, okay, or things that you have available. But if you have, and this is the recent case, if you have a computer program or other database that can readily compile what's been requested, there is a duty to do that. So there's kind of a line in what's required. So if it's something we can put together by maybe pushing a button and answering a couple questions, then we need to provide it. But we don't have to put in extensive work, going to multiple sources to compile something. So it's kind of a strange line. The PERS case left it open, which is why I have a question there. In a footnote, they discuss this and they cite to some Ohio cases. But 3 weeks ago, they let us know what they really meant, which was what I just told you, that if you have an easy way to do it electronically, please do it. Otherwise, you provide what you have. So if you have a hard copy record, you redact and copy that, for example. So there's many Attorney General opinions on this subject. Most of them, in my opinion, tell us kind of what I've told you here and what the cases tell us. So I don't know that there's anything overly new in them, but certainly if you have questions, you can search for them. You can talk to your legal counsel about opinions, and they may be aware of some opinions that are available. And then, of course, local governments can ask for Attorney General opinions, and so it may be that you have an issue pop up, and you talk with your legal counsel, and they say, you know what, we want to get an Attorney General opinion, and you can do that as a local government. So here's some general tips and reminders. You have to respond within 5 days from receiving the request. You have to either give it at that point. You have to let them know when you'll have it ready. You have to tell them we don't have it, agency X has it, or we just don't have it. So basically that's what they want. And you can, like I said, you can give them a time frame if you don't have it ready in 5 days, but I think what happened was the legislature got a lot of complaints that people were sending requests and never getting a response. So they told us we have to respond within 5 days. Yes?
Okay, all this information on AB 31 applies only to state agencies, does not apply to the local government. They were especially accepted. I was involved in that legislation.
Yeah, you are exempted from AB 31. Yeah. Verbal requests are also allowed under the Public Records Act. The distinguishing factor now is that an extraordinary request must be in writing. A general request, I guess you could say, can be verbal. In my mind, the way I think about it is if it's something you have readily available, like minutes from a meeting or something like that, to me, that's probably something someone may call you about and say, hey, please send me this, and you should do that. But if it's something that is deemed extraordinary, then it has to be in writing. You want to log them and handle them appropriately. And the reason I say log them, it's not required under the law, but you just want to make sure you're following that 5-day rule. And again, talk with your legal counsel. Make sure you have a policy and all of your employees know that. Because one thing I always worry about is, the front desk person may not be expert in these areas, and people may call and ask for things, and we want to make sure that person knows how to respond and is not saying, oh, no, we don't give those out. Talk to you later. And we want to make sure they know what to say. So again, extraordinary requests must be in writing. Legal custody does not equal ownership. I just put this in here just for you to think about. There's an NAC provision that talks about this. And I think the reason it matters is sometimes you'll have copies of things, but you're not really the record holder. You don't want to, I would say, have those hanging around past the time you don't need them, but there is that question to sometimes think about. So for example, legal counsel may have a contract they're reviewing, for another entity in the city. It's not really their record. It's a record they're reviewing for that entity. So you just want to be careful about that and think about that just because you have it, you may not have the official copy or the official record. Yes?
Would that apply to a lot of times, we are required to get copies of a different agency's record? They have the original, we have the others that we
I would say that is a good example of where it might apply, because you don't have the official record, for example, from Oklahoma, where somebody may have gotten married. I'm just making up an example. I think it's appropriate to say you should contact the state of Oklahoma for that official record. How long you have to keep it is kind of, I think, maybe a different question, and that question is best answered possibly by looking at the retention schedule, seeing why you have it in the first place, because sometimes we have things just because we need to look at them for a little while, and then they're no longer useful, and they're not part of our official record. So if that becomes part of your official record, it could be that then that is also available to people, maybe with the caveat that we have this copy dated in 2005, you may wish to contact Oklahoma to get a more recent copy or something like that. Yes. And one thing that hopefully the records retention schedule helps you with and following it is to maybe minimize some of that and make sure you don't have multiple copies running around. Because again, if you have it, you're supposed to provide it. And so if somebody has a courtesy copy sitting on their desk in a folder, and we say, oh no, we don't have it, we destroyed it, if they find out about that, we lied and we should have provided it, right? So I always advise everybody, follow the retention schedule, and then if you need a special one, a specific one, come to Library and Archives State Records Committee meeting. I actually sit on it for the Attorney General, and we'll get you your own schedule. So again, where is it? Sometimes it's not in your custody or control. You want to tell them you need to get the official copy from agency X. Other times you may need to tell them this has been destroyed or transferred to state archives pursuant to a schedule. So you want to let them know that. You can have verbal discussions to clarify the request if you want to, but you still need to respond in writing. That's what the law requires, so that's what I'm telling you to do. And I think you should document any change they make to the original request in writing as well, just to be safe and careful. You can get actual costs for your records. That would be postage, copies, toner, paper, things like that. Extraordinary use, you can get up to 50 cents a page. And county clerks are now limited to charging no more than 50 cents a page for copy of court records. So that was from AB 31 in 2013, and that should apply to the Carson City District Court. Yeah. So actual costs, again, it's part of our duty, but extraordinary use costs cannot exceed 50 cents a page. I get questions all the time, well, what if the record's electronic? What if it's an Excel spreadsheet? You know, and we're going to email it, what do we do? Generally speaking, in our office, now granted, we don't get a ton of requests. We provide those without charge, generally. But it is a good question, and the legislature really didn't tell us. They said 50 cents a page, which sort of implies to me that we're printing it and making it available hard copy. The legislative history shows that I think they were actually thinking that they didn't want any charge, and also there's some notes in the legislative history about electronic records, you know, again, being available for free. So I think that may have been the legislative thought, that if you're not printing it out and making it available hard copy, no extraordinary. I put this in here for you because this would apply, and this is sort of an open meeting law thing, but also public records. No charge for meetings and recordings of meetings now, so that would apply for you. Court reporter transcripts is an exception, so if you ever have that situation, you'll want to look at this provision and make sure that you're following that. You also want to include that on your fee list. So if you ever have a court reporter, include that per page fee on your fee list so that everybody knows. You need to have a fee list posted in all of your offices that lets people know what you're going to charge. And if you want to, again, I'm going to tell you multiple times, have a policy, have a policy, have a policy. If you want to waive fees, you can do that. Some people have policies that they waive fees if it's under a certain amount, under a certain number of pages. There's nothing wrong with that, but just have that in your policy and apply it consistently because we don't want allegations of favoritism or, you know, lack of favoritism. You know, if somebody comes in and requests things all the time, we need to treat them the same as we do somebody we don't see very often. Yes? Extraordinary use of personnel would be under the same. It's 239.055, 50 cents per page. So what we do in our office, because it says not to exceed 50 cents a page, my concern was I don't want to look a district court judge in the eye and say, well, we always charge 50 cents a page because it says not to exceed. So we calculate it what I call the old way, which means we keep track of employee time. And, you know, let's say we bill $20 an hour for a legal researcher. If we provide 10 pages, we get $5 back. So I just want to be able to show later how we did it, because there could be times where it's really only 40 cents a page, and I just want to be able to tell a judge that if we're ever challenged. So that's how we've decided to do it. Again, though, I know we don't get probably as many requests as you do. So, and if ever you want to look at it, our policy is available on our website, and we've laid these things out and our fee list as well. So just in case you want to, you know, steal some tips or thoughts from us. Policy and procedure, so again, have a policy now, because I worry about that 5 days. It can go by quickly. So you want to make sure everybody knows what to do with one when they get one. Yes?
That 5 days only applies to state agencies. All that was in that bill, 31, and it only applies to state agencies. It doesn't apply to
The 5-day rule was actually added in 2011, so that's before AB 31, which AB 31 is 2013.
Yes, I know.
Okay, so that was in AB 31.
So I understand, but 5 days still was not meant to apply to local governments.
Okay, well, I would have to look at 239.0107 and double check that, but I don't recall that there's an exception for local governments in 239.0107. So I'll defer to your legal counsel on that. Risks of non-disclosure. This is just to let you know that if a person doesn't like the decision you make to not release the records and they challenge you in court, there can be fees. They can get attorney's fees and costs for that. So I just want everyone to know that. We want to be careful and really think about what we're doing because there could be a cost to the agency. Good faith immunity we talked about briefly. It's for the public officer or employee, and it is in the NRS for you. Again, it's for the public officer or employee, and so we believe that to receive this good faith immunity, the agency itself, not legal counsel, should make the decision regarding the disclosure of information. If somebody doesn't like the decision or if they think you're not following the law, their only recourse is to go to district court and get an order from the judge saying, please let me look at the record. That's their recourse. People call our office all the time, and unlike open meeting law, we don't have the ability to follow up on those complaints. We say 239-011, you can go to court. So, and this tells you more about that process. The burden on judicial review is preponderance of the evidence. So that means more likely than not 4951, essentially. So we have to show 4951. That's what they tell us statutorily. I think as it plays out in court, it might be a higher burden. I'm not sure. I mean, I think the court would say they're doing a preponderance, but it just seems like lately it's been not in favor of the agency in any time something is withheld. So this was just something I had in my presentation just because I thought it was interesting. Apparently there have been complaints about requiring somebody to make the copy themselves, and so now the legislature said, well, if they want you to make the copy, you should make the copy. So this is more for state agencies, although I think there are thoughts that this may eventually apply to local governments as well, which is about designating an employee as a records official. And again, if you want to look at our forms and our procedures, I think they can be helpful guidance, and so I've told you a little bit about that there. There's a master form available on the Library and Archives website, a manual for state agencies, which again, it's specifically says it's for state agencies, but I think it gives you some helpful tips on how to follow the law and answer requests. And then we also have the new regulations that were just adopted on the Library and Archives website. So that's the website there to go to. If you click on that, that will take you to the public records section, and I do think there's a lot of helpful info there. So, do we have any more questions, or everyone's really tired now because it's almost 4? All right.
Okay, we indicated on the agenda we'll get you out of here by 4, and we will do that. I thank you all for showing up and for taking the time out of your afternoon to participate in this. Listening to lawyers for 2.5 hours is not everybody's idea of fun, but I don't feel sorry for you because I do it every day. Just a few things. First, thank you to Yvonne, George, and Sarah for helping us out with this today. Really appreciate it, and I know I learned some things. I'm sure my team did too, and hopefully you folks did as well. In terms of communicating with our office, George made a point, and a couple others did too, that time is helpful for us. The sooner you know of an issue, the sooner you can give us notice that there's a problem or a concern or anything like that, the more time we have to research it, look into it, and give you a good answer. But I do want to say that don't feel like you can't bring something up at a meeting. I want you to do that in particular with regard to the open meeting law. We're supposed to be the watchdogs, and we're supposed to be, keeping an eye and making sure we're on the agenda. But we're human beings, and sometimes we're thinking about the next agenda item, and maybe we've got questions about substantive law, and it doesn't hurt anything at all for a member to say, are we straying? Are we within the agenda item here? And we're happy to offer some opinion on that. So don't hesitate to do that. When you ask for opinions from our office, you can ask for them in any form that you want. You can ask for them with a telephone call. You can ask for an opinion by an email. You can ask for a formal written opinion if you'd like to do that. You can make arrangements to come in and talk to us in person, and we're happy to give you those opinions in any form that would be most helpful to you. But I do want to stress that when we talk to you as your counsel, on behalf of as your counsel, when we give you information, that information is confidential, just like it is between private parties. The attorney-client privilege applies. The privilege doesn't belong to us. I can't talk to you, Donna, and then go tell John Barrett or Carson Now or whoever I might want to tell about the conversation that we have. It's a violation of my ethical duty, and we can't do that. But you can waive that privilege. You can do that intentionally, and sometimes you can do that unintentionally. Like if you get an email from me saying this is my opinion, and you forward that email to somebody else, you've waived that privilege. You've waived any right to say that that's confidential anymore. So we wanted to make sure you were alerted to that. The last thing I'll mention is that we are, as everybody knows here, in the middle of a legislative session. We're tracking changes to all these laws that we've talked about, and we will keep an eye on them. We debated among ourselves, should we wait until after the session so we can fully update everybody at the time that we have this? We made the decision. We thought it was important enough to get this going quickly, but there will be updates. Your counsel, whoever your assigned counsel is, will be updated on any laws that have any impact on this. We'll do some update sessions as we go along here, but I do want you to, look, you're welcome to watch them too and have discussions with us, but we're watching them for you. So appreciate your attention. We got some really great questions here today, and once again, I appreciate your time. Thank you very much.